Good afternoon. My name is Joe Rosenbaum. I'm the Secretary Treasurer of the California Board of Accountancy, and I'll be presiding over the afternoon session today. Welcome to this January 26, 2023 Board of Accountancy meeting. I'd like to first state that the CBA has provided the opportunity for the public to participate not only in person here at Sacramento headquarters, but also via the WebEx platform. When we take public comments, we will begin by taking public comment from those individuals attending the meeting personally here in Sacramento, and then I'll ask the moderator to open up the lines for public comment. Excuse me. You will be allocated up to 5 minutes for any public comment. I'd first like to note that CBA President Salazar and CBA member Jacobson will be participating remotely, and there are no members of the public at their locations. But before we get started, I wanted to make a note. There's a typo on the Enforcement Program Oversight Committee, or the EPOC agenda, of a start time of 9:30 tomorrow, Friday, January 27. But the EPOC meeting will actually commence at 9:00 a.m. as noticed. Okay, so let's see if we can establish a quorum. Ms. Reed?
Nancy Corrigan. Nancy Corrigan, present. Carrie Ann Farrell-Hines. Dan Jacobson.
Here.
Christian Lotta. Present. Dee Dee Owens. Present. Joe Rosenbaum.
Present.
Katrina Salazar.
Present.
Michael Savoy.
Present.
And Evangeline Ward. Present. We have a quorum.
Thank you. To start the meeting, I'd like to read into the record the following. The CBA's mission is to protect consumers by ensuring only qualified licensees practice public accountancy in accordance with established professional standards. This mission is derived from the statutory requirement that protection of the public shall be the highest priority for the California Board of Accountancy in exercising its licensing, regulatory, and disciplinary functions. Whenever the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. With that, let's go into our agenda, and agenda item 1 this afternoon is petition hearings, and the very first one we have is Michael Deutschman.
Good afternoon, everyone. My name is Matthew Block. I'm an administrative law judge with the Office of Administrative Hearings in Sacramento. We are going to be recording this hearing electronically without a court reporter. So I could ask if everybody could just please speak as clearly and slowly as possible into the microphone. So I'm going to go ahead and take us on record at this point. We are on the record before the California Board of Accountancy, State of California, in the matter of the petition for reinstatement of revoked certificate by Michael Deutschman. This is Office of Administrative Hearings, case number 2022-100413. Before going on record, we've already established that a quorum of the board is present, but I would ask that the members identify themselves for our record, starting with the member furthest to my left, which I believe is Ms. Farrell-Hines.
Good afternoon, Carrie Ann Farrell-Hines.
Dee Dee Owens. Christian Lotta.
Nancy Corrigan.
Michael Savoy.
Joe Rosenbaum.
Evangeline Ward.
And the two members who are participating via distance.
Dan Jacobson and Tustin.
Katrina Salazar.
All right, thank you. May I take the appearance of the Deputy Attorney General, please?
Good afternoon, Deputy Attorney General Ted Durkar.
All right, good afternoon to you, sir. And Mr. Deutschman is present and representing yourself, correct? All right. So before we went on record, we discussed the procedures will be followed in the hearing on this matter. The Deputy Attorney General first will present the petition and give an overview of the case. After that, Mr. Deutschman will have the opportunity to make a presentation under oath on his own behalf and to call any witnesses that he sees fit. The Deputy Attorney General will then have the opportunity to ask questions of petitioner, as will all members of the board. Mr. Deutschman, at the end of the hearing, the board will go into closed session today to deliberate on the petition. You won't receive an answer today, but will be notified in the mail at a later date, okay? If you have any questions during the hearing, Mr. Deutschman, let me know. Neither myself or Mr. Dakar can give you legal advice, but we may be able to help you understand the proceedings and why we're doing and saying certain things, okay? So with that, is the Deputy Attorney General prepared to proceed?
Yes, Your Honor.
All right, go ahead, sir.
I'm appearing today on behalf of the people of the state of California pursuant to Business and Professions Code Section 5115 and Government Code Section 11522 on this petition for reinstatement by Michael Deutschman. I'd first like to mark for identification and offer into evidence as Exhibit 1 the original petition packet with its accompanying documents. The board members and petitioner and Your Honor have been provided with a copy of the same set of this exhibit. The documents total 288 pages. They're sequentially marked starting with MD-PET-001. And the notice of hearing in this matter is at page 282, but I would go ahead and offer that exhibit into evidence at this time.
All right, so just so our record is clear, I have followed in marking the exhibit in accordance with the way that you have marked all of the individual documents. So Mr. Deutschman, as Mr. Dakar said, the entire exhibit totals 288 pages, but it will be marked as follows. Exhibit number 1 will be the petition consisting of 30 pages. Exhibit number 2 is the order denying petition for reconsideration. Exhibit number 3 is the decision and order and proposed decision. Those are pages 34 through 41. Exhibit 4 is the accusation, pages 42 through 47. Exhibit 5 is the Public Company Accounting Oversight Board order summarily affirming findings of certain violations and imposition of sanctions for those violations. Those are pages 48 through 67 of the exhibit. Exhibit 6, Securities and Exchange Commission order making findings and opposing remedial sanctions, and that's pages 68 through 71. Exhibit 7, SEC order instituting administrative and cease and desist proceedings. That's pages 72 to 75. Exhibit 8, SEC order instituting administrative and cease and desist proceedings, pages 76 through 118. Exhibit 9, SEC initial decision, pages 119 through 241. Exhibit 10, petition for review of initial decision, that's pages 242 through 279. Exhibit 11, license history, pages 280 and 281. Exhibit 12, notice of hearing, pages 282 through 284. Exhibit 13, Colorado State Board of Accountancy certificate, pages 285 to 286. And finally, Exhibit 14, New York State Board of Accountancy certificate, pages 287, 288. Mr. Deutschman, have you had the opportunity to review the petition packet?
I did.
And do you have any objection to any of those exhibits being admitted in evidence?
I do not.
All right. All 14 exhibits, broken down as I stated, consisting of a total of 288 pages, are admitted in evidence. Mr. Dakar?
Yes, I'd now like to offer a summary of the case.
Please do so.
Michael Deutschman received his CPA certificate number 99008 back in 2007. And I'll give you a summary now of the administrative case that resulted in the revocation of his CPA license. The CBA's first amended accusation against Mr. Deutschman begins at page 42, which I believe is Exhibit 4 in the materials. That accusation was filed in April 2019, and it alleged that Mr. Deutschman was subject to discipline because he had previously been disciplined by the Public Company Accounting Oversight Board. I'm going to be referring to that entity repeatedly, and I'll refer to it as PCAOB. The accusation explains that in January 2015, the PCAOB issued an order that barred Mr. Deutschman from being an associated person of a registered public accounting firm and ordered him to pay a $35,000 fine. And I'll just explain for those of you who aren't familiar with it. Registration is required for all firms, registration with the PCAOB, that is, in order to prepare or issue an audit report for a public company or a broker-dealer, or to play a substantial role in those audits. Let's see, the other parties that were disciplined in that same PCAOB order for the same course of conduct included CPA Hamid Kabani and the firm Kabani and Company. Those parties were before you previously petitioning for reinstatement, so that would be why the facts here may sound familiar to you. You've heard them in the context of the previous petition. Mr. Deutschman and Mr. Kabani, they appealed the PCAOB decision to the SEC, and 2 years later in 2017, the SEC issued an order sustaining the PCAOB decision. They then appealed that SEC order to the Ninth Circuit Court of Appeals, and in 2018, that court denied the petition by Mr. Deutschman, Mr. Kabani, and Kabani and Company. That 2018 court decision made the original 2015 PCAOB decision final. And then the case before this board, the accusation case, followed. It was that series of appeals that is the reason why the misconduct, which you'll hear about, that was occurred back in 2008, why it didn't make it into a CBA accusation until 2018. Mr. Deutschman, he did contest the CBA accusation, and it went to hearing in June 2019. And the administrative law judge's proposed decision, which revoked Mr. Deutschman's license and imposed $6,800 in costs, that's at pages 35 to 41 of the packet, which is, I believe that's part of Exhibit 3. The board's order that adopted the proposed decision, that's at page 34. Also, I think part of Exhibit 3. And Mr. Deutschman, he petitioned the board for reconsideration of the decision, and the board's order denying reconsideration is at page 33 of the packet. The revocation order became effective in September 2019. And I'll provide a summary of the circumstances behind this board's decision against Mr. Deutschman. Mr. Deutschman and Mr. Kabani were the only two partners in a small firm called Kabani and Company. In June 2008, the PCAOB notified Kabani and Company that it would be inspecting the firm's records for its 2007 audits of 3 public companies. Mr. Deutschman was the concurring partner on all 3 of those audits. Kabani and Company found that the audit files had the kind of problems that could result in deficiency findings by the PCAOB. And the PCAOB, SEC, and Ninth Circuit Court of Appeal decisions all found that Mr. Deutschman and the other respondents engaged in a wide-ranging and resource-intensive effort to improperly alter documents in audit files in an attempt to improve those files and deceive the PCAOB inspectors. Mr. Deutschman participated in the so-called cleanup effort to eliminate deficiencies from all 3 audit files. And that's in violation of PCAOB accounting standard number 3 that allows information to be added to the audit work papers after the fact only if the person denotes their name, the date of the addition, and the reason for it. And no information can be altered or deleted once the audit file is final. Kabani and Company and those involved in the cleanup effort did not make notations about their changes. And when the PCAOB staff performed their inspection in October 2008, they were not informed that the audit files had been altered. There was an evidentiary hearing on the PCAOB's charges, and the hearing officer issued a decision in April 2014, which found that all the respondents had participated in a widespread and resource-intensive effort over several weeks in 2008 to alter documents in the audit files of the three audits in an attempt to deceive the inspectors. Mr. Deutschman and Mr. Cabani went ahead and challenged that hearing officer's decision, but the PCAOB adopted it, and that decision starts at page 48 of the materials. That'd be Exhibit 5, Your Honor. The PCAOB found that Mr. Deutschman had violated Rule 3100, which requires compliance with audit standards, and Rule 4006, which requires cooperation with PCAOB inspectors. The PCAOB decision indicates that Mr. Deutschman acted with a high degree of scienter, which means knowledge of the wrongfulness of his actions. I'm going to point out some key findings in Exhibit 5, the PCAOB decision. At page 53, the decision states that Cabani, Deutschman, and Kahn participated in the scheme to alter the work papers and to provide the altered work papers to the inspectors. At page 56, the PCAOB addressed credibility issues, finding that the respondents were not credible on issues pertaining to work paper alterations, including their claims to not recall certain important events, inconsistencies between their investigative and hearing testimony, and attempts to distance themselves from incriminating evidence. At page 65, the PCAOB states the rationale for the serious discipline that it imposed, saying that, quote, misconduct is especially troubling and deserving of serious sanctions, whereas here, respondents went to considerable lengths to conceal their actions and might have been successful in deceiving the board if Saeed had not reported his concerns, unquote. Saeed was the whistleblower that had brought the matter to the PCAOB's attention. The CBA accusation against Mr. Deutschman was based upon the discipline imposed by the PCAOB. In spite of the decision by the federal hearing officer, then the PCAOB decision adopting it, the SEC decision sustaining the PCAOB, and the unsuccessful federal appeal in federal court in 2018. In 2019, Mr. Deutschman still fought the charges before the board. And then in the decision by this board, it was found that Mr. Deutschman participated in the creation of false documents given to the PCAOB inspectors. That's at page 38, which I believe is Exhibit 3. The board's decision also found that, quote, respondents' misconduct was part of an egregious scheme to deceive regulators. In other words, his actions smack of fraud, conduct that disqualifies one from being a CPA. That's at page 41 in Exhibit 3. As of the 2019 hearing, Mr. Deutschman had not made any payments to the PCAOB on the $35,000 fine. I don't have any information in the packet about whether he's made any payments since then. At pages 40 to 41 of Exhibit 3, the decision addresses the passage of 11 years at that time in 2019, since the 2008 misconduct that resulted in the PCAOB discipline. This board's decision found the passage of time unimportant for two reasons. First, Mr. Deutschman didn't provide evidence of rehabilitation or mitigation. And second, Mr. Deutschman didn't take responsibility for his actions. He spent years appealing the PCAOB decision, and his arguments weren't credible. Moving on now to another SEC order previous to the PCAOB matter. There was a prior disciplinary order from the SEC involving Mr. Deutschman. It was based upon conduct in 2004 when Mr. Deutschman he was disciplined for, the conduct occurred in 2004. He was disciplined in 2008 when he entered a consent order with the SEC. The nature of the misconduct is that he prepared and issued a public company audit when he was not registered with the PCAOB, and he knew that was required. The order required him to cease and desist from engaging in further violations, and it censured him. There wasn't any fine, though. The next matter that I want to cover is a pending SEC matter involving Mr. Deutschman. That takes up, I think, the bulk of the materials here, some very long documents. I'll try to provide a efficient summary for you. This newer SEC proceeding has a disciplinary order in it, but it's not final at this time. It's under review and it's been contested. Mr. Deutschman is legally challenging that order. But in December 2017, an SEC order instituted disciplinary proceedings against him and 4 other respondents, including the accounting firm Anton and Chia LLP. That's, let's see, pages 76 to 118. So that is Exhibit 8 in the materials. In February 2021, the SEC reached an initial decision as to Mr. Deutschman and 2 other respondents. And that's pages 119 to 241. So that's Exhibit 9 of the materials. In March 2021, Mr. Deutschman and 2 other respondents who were the subject of that initial decision, they filed a petition asking the SEC to review that initial decision. That's pages 242 to 279, and that is Exhibit 10 in the materials. And so because of that petition by Mr. Deutschman and the other respondents, the initial decision by the SEC is not a final decision at this time. Mr. Deutschman's petition in this pending SEC case summarizes his prior discipline by the PCAOB as follows. He says that his livelihood was taken from him and his career was destroyed by the belligerent behavior of the government. That's at page 278. The initial decision from the SEC explains that Mr. Deutschman was an audit partner for the firm Anton and Chia, and he was the engagement partner for test engagements for a client called Accelera, one of 3 attest clients that is the subject of the SEC interim decision. And the key pages are, I believe, 77 to 78 in your materials. At page 77 in the second paragraph, the SEC's interim decision says, Accelera vastly inflated its financial position and results by treating another company's revenues, assets, and liabilities as its own. And in page 77, first paragraph, it says that the respondents egregiously deviated from multiple PCAOB standards and ignored numerous red flags indicating the company's financial statements and public findings contained material misstatements. Moreover, Anton and Chia, Wall, and Deutschman were reckless in not knowing that the statements for Accelera and Premier were false and misleading. Premier being another one of the 3 companies, public company audits that's the subject of this SEC decision. The interim decision called for discipline against Mr. Deutschman, a $40,000 fine, and a permanent denial of the privilege to practice before the SEC as an accountant. But as I said, that's not a final decision. It's under review at this time. The most recent activity in that SEC case is an order extending the time for the SEC to issue a final decision. And that final decision, according to that order, is due this coming Monday, January 30th, 2023. Now I'll provide an inventory of some of Mr. Deutschman's documents, his petition to this board. The petition begins at page 9 of your materials, and I believe that's Exhibit 1. Mr. Deutschman's narrative answers to some of the questions, standard questions in the petition, are attached as pages 15 to 17 of your packet. At page 15, he addresses the pending SEC action against him. He states that he expects that the legal challenges to this SEC order will last for years. He provides a critique of the government's expert witness and claims that the case would have been dismissed after the expert was impeached, but the court was partisan, so therefore the case continues. In other words, he's claiming that he would have won, the case would have been dismissed if the judge had followed the law, but he's saying that the judge was biased against him. At pages 16 to 17 of the narrative provided by Mr. Deutschman, he explains why his petition should be granted, and he describes his long career as a CPA, starting in 1971. He says he started with a firm that is now KPMG. Then he worked as a controller for a company that is now CVS, the drugstore chain. He served as a technical manager for the AICPA and prepared GAAP guides while in that role. He also worked as a senior staff accountant for the SEC's Division of Corporate Finance, and says he served as a peer reviewer for many firms, and he's been an engagement partner for hundreds of public company tax returns. Then he addresses his 3 SEC disciplinary cases and notes that no investors were harmed by his actions. In 2004, he states that he issued an audit opinion without registering with the PCAOB. He claims he was in the process of registering and did that work as an accommodation. I guess he means as an accommodation for the client that wanted him to do the work. With regard to the discipline for altering work papers on the 3 public company audits in 2008, he denies that he engaged in the wrongdoing. And with regard to the ongoing litigation for the most recent disciplinary order, he claims, quote, "This case is a violation of the constitutional rights of the defendants and an outrageous overreach by the federal government," unquote. Mr. Deutschman has performed CPE, continuing professional education, since his license was revoked. At pages 18 to 27 of your materials, I'm not sure which exhibit that is. I'm sorry, but at any rate, at pages 18 to 27, he lists 92 hours of coursework and provides the completion certificates for those courses. Mr. Deutschman submitted a recommendation letter at page 30. The author, James Watts, is an attorney and a licensed securities professional in the Virginia, D.C. area. Mr. Watts used to be a consultant for Mr. Deutschman, providing valuations for companies that Mr. Deutschman audited. The letter says that he enjoyed working with Mr. Deutschman and thought that Mr. Deutschman's work was ethical and complete. He praised it. And the letter, however, does not reflect knowledge of Mr. Deutschman's wrongdoing or discipline, and it does not say anything about rehabilitation. That concludes my summary of the evidence, Your Honor.
All right, thank you. Mr. Deutschman, are you prepared to testify in this matter?
Yes, I have some comments to make.
Would you please raise your right hand, sir?
Yeah, I have some comments to make, yes.
Would you please raise your right hand?
Sure.
Do you solemnly swear or affirm under penalty of perjury that the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right.
Okay, the first thing I'd like to do is I got a letter of recommendation from a partner at who's been a partner at Deloitte for 22 years, and he's known me for 30 years. So I'd like to put that into the record because I think it would be helpful. May I do that? Well, I could read it into the record if that's...
Yeah, Mr. Deutschman, first of all, can you pull the microphone closer to you and just make sure that...
I'm sorry, I can't hear you. Can you speak up, please?
Could you please pull the microphone?
Yeah, I'm sorry. Is
Okay,
that better? Yeah,
that's better.
I'm sorry.
Mr. Durkar, do you want to have a look at the document?
This is the document over here. I'd like to put that into evidence if I can.
We,
Is this better? I'm sorry.
You keep touching it, it turns red. It has
Okay, put my hands back, okay.
I've had a chance to review it, Your Honor.
do you have any objection to it being marked?
No objection, Your Honor.
And any objection to it being received in evidence?
No, Your Honor.
All right. The letter is from who, Mr. Deutschman?
Thank you, Your Honor. So I've read as much as I can about the board's procedures. and-
Hold on, Mr. Deutschman. Who is the letter from?
The letter's from Joseph First, F-E-R-S-T.
And is there any way that we could have copies made for the board members?
Sure. Absolutely, can make as many copies as necessary.
All right. Absent objection, the letter from Joseph First will be marked as Exhibit A and admitted in evidence. Go ahead, sir.
Okay. So I've read the board's criteria, so I'm responding to the board's criteria as well as I can. So I think you're interested in activities since license revocation. That's a big part. So my license was revoked 3 years ago. But unfortunately, since my license was revoked about 3 years ago, around the time of the revocation of my license, my domestic partner of 20 years, Marcia Merritt, exhibited symptoms of a serious neurological condition called PSP. I spent the last 3 years caring for her at home. I cared for her 24/7, and she passed away at our home in her sleep on November 25th, 2022. I had to do everything for her. It was 24 hours a day. I got every kind of care for her imaginable. So for the disease basically, once it presents itself, kills somebody in 4 years. So for the last 3 years, it's actually a godsend that I lost my license because I was able to take care of her for the last 3 years. Matter of fact, coming out here, it almost felt like a free thing that I was able to get on a plane and actually have some freedom, because for last year, I couldn't even get out of the house for a year. So that's all I've been doing for the last 3 years. And I had Stanford Medical Center send me all sorts of analysis of her condition, and they told me that it would take a team of people to care for her. Well, I was the team of people that cared for her. So that's what I've been doing for the last 3 years. I haven't been able to do anything else. And she passed away in her sleep on November 25th, 2022. So that takes care of that. Now, as far as the nature and severity of the offense for the PCAOB, now with all due respect, what the attorney from the state of California didn't say in his analysis was that the administrative law judge assumed he gave me a 2-year, first of all, I didn't own 1% of this firm. Hamid Kabani owned 100% of the firm. And he ran the process. It was his firm, not mine. I didn't own 1% of this firm. And the final analysis of the administrative law judge was that he should be banned for life and that I should have a 2-year timeout and pay a $35,000 fine. What the attorney also didn't point out was I paid the $35,000 fine. And what he also didn't point out was that what the administrative law judge says, he was critical of me. It was a very involved case, and they did a very thorough job. And he came to the conclusion that my culpability was that I didn't talk Mr. Kabani out of the things that he was doing. It's right in that opinion. So I would have felt a little more comfortable had that been entered into evidence. So I basically got a 2-year suspension, which is long since done, paid a $35,000 fine. I didn't own 1% of the firm. So the question then is, what sort of rehabilitation could I do so that something like that would never reoccur again? What could I do? Well, what I presented at the hearing was something that I didn't think the administrative law judge was comfortable with, but I think it's helpful. I said I could have put better controls into the work papers than I did. And I think that's very important to understand, because I know that some of the people on the board are accountants and some people are not. But I also have something that I would like to place in evidence, which is an article from an expert on work paper preparation. He's got a long history of work preparation, and I would very much appreciate it if this could be put into evidence, because I think this gets to the core of the issue in this case. It's over here, sir. It's over here. And the core of the issue in the case is the PCAOB has a rule where if somebody performs audit work on a file, you have 45 days to document the audit work, and then you can't document it any longer. And that's their thing, because for the longest time, audit files were always kept open. People trusted accountants, and they kept the audit files open. So they could be open for years. You could put things in the file. You could take things out of the file. People trusted us, and the files were open, and they were kind of always being adjusted. Well, the PCAOB introduced these rules, and they said, when they started to do the work, they said it's 45 days, and that's it. You can't do anything to these files anymore. Well, I don't think that's good enough. I don't think that's good enough, because, I think that if I were to work in a firm again, the rule that I would want to have, and I wouldn't work in a firm unless they did this, is that the work would have to be documented when it was done. Because if you don't document the work when it's done, 1 week passes, 2 weeks passes, 3 weeks passes. And then how do you remember what you ever did when the work is? So if you look at a document and you check it off that you inspected and you looked at the document, and it's 20 days later, that doesn't make any sense. So they have this magical rule about 45 days and you could put something in the file. That's not good enough. So, and that creates the tone at the top. So if the tone at the top in a firm is that we're not going to go ahead and accept any work that any of the staff does unless you document it right then and there, that I think is the best approach, so that this remedial approach, so that this would never happen again. And I would never work in a firm that wouldn't do this, because I never want to go through anything like this again. I would never want to go through anything like this again. If I have staff and they come into my office, I'll say, when you do the work, write it down. And if you don't write it down, then you haven't done the work. It's real simple. So that's the best thing I can come up with as far as remediation is concerned in this regard. Now, as far as these other matters, the 2008 matter, I mean, I was in the process. Somebody contacted me at the 9th hour in 2004, which is 18 years ago, and said, I have a company and it doesn't have any assets and it doesn't have any liabilities and it doesn't have any sort of anything. You know, we need to file something. And I said, I'm not registered with the board. I'm not able to sign this thing, but I'm in the process of registering. So I took a look at what he had, and I didn't accept any fees or any money for it, nothing. And I helped him with it, and the opinion read, I was in the process of registering. I didn't accept any money for it, and there wasn't any investors harmed, and there was just nothing like that. So I shouldn't have done it. I take responsibility for it. I actually completely take responsibility for it, just like I take responsibility for the Kobani matter. I mean, I don't think that judge was wrong. I should have persuaded him harder to change some of his behavior. I guess I had an option to quit. Maybe. I don't know. But so in the role I was in, what I could have done was, so I take responsibility for some of the things that happened. I never want them to happen again. What I could have done was I could have had better controls in place. So maybe the firm would have been more comfortable and it would have had more credibility to the regulators when they came in. So if the regulators knew when they came in that nobody in the firm was doing any work unless they signed off on the work right then and there, then that would have taken care of all of the distrust and the view that somehow we were dishonest and we weren't doing the work the way we were supposed to. So I take responsibility for everything that I could take responsibility for, and could have been better controls, and I could have definitely spoken to him and maybe persuaded him to conduct his behavior in a better way. Now, as far as the last item that's involved in this, I think that, but one thing also I'd like to point out if I can, and I appreciate this opportunity the board has given me, I really do. Something talks about the nature and severity of the offense. Well, my license was revoked, 48 years was revoked because of this PCOB matter. Well, the PCOB prescribed a 2-year ban and a fine. I paid the fine. The board, based on this, prescribed a much harsher penalty and revoked my license that had been maintained in good status for 48 years. So the PCAOB said 2 years, and you should have talked them out of doing this, and the board came in and ignored all of that and revoked my license of 48 years and took away my livelihood that I had for 48 years. And the Kobani matter emanated from an inspection that occurred 15 years ago. One other thing on this other matter that's pending before the SEC right now, if I can speak to that, I appreciate it. About 2000 and I had it in my file, but somehow the names of the people in the file were redacted, which I felt a little uncomfortable with when I came here today. Because what happened, maybe about 2010 or 2011, thereabouts, somebody came to our firm at Kobani and Company, and they said there's a CPA and the SEC has brought this case against them, and nobody is willing to help him. Nobody wants to help him. They're afraid to go against the government. They don't want to help him. He's going to lose his license. He's not going to be able to support his family. Is anybody willing to take up his case? And they say no good deed goes unpunished. Well, I decided to take up his case. And when I took up his case, I won't name names because apparently that causes difficulty, but they had an expert, and I read the case that he brought against this accountant who's a California CPA. And when I read his report, I could tell that he hadn't ever audited a public company. It looked like a report written by a college professor, which is fine, or by somebody who just didn't have the experience of signing an opinion of a public company. And what basically happened in that case was that the SEC wanted to fine him. They were in a federal district court in New York in front of a judge called Judge Sullivan, who's now an appellate court judge. And what happened in that case was that they ruled that the SEC was asking for millions of dollars of fines against this guy. And when I read it, I could tell he was signing opinions as an audit partner on public companies. Well, to be an audit partner in a public company, you need 15 years of experience. Easy. It's really complicated work. And I could see looking at what he had maybe 3 or 4 years of experience in he had 3 years in like a big 8 firm, and then he was off on his own. And here he was, an engagement partner in a big in a small firm auditing an international company, which he wasn't qualified to do. So what the SEC did with this expert was they portrayed him as somebody who was just dishonest, just horrible person. Went to a federal district court and tried to get millions of dollars of fines against him. They could fine him millions of dollars, And basically, they tried to intimidate me not to testify on his behalf, which I did. And the judge in that case, Judge Sullivan, saw through what they were trying to do, and he went ahead and he basically fined them like $100,000. The insurance proceeds covered the $100,000. And the Board of Accountancy basically took away his right to audit companies, but gave him a license to do tax returns. So he's been able to support. I saw his face. I can give you his name. It's Tim Quintanilla. I saw his thing before I came here. I saw him online, and he's basically earning a living doing tax returns. So if I hadn't done that, he would have been bankrupt, and his entire family would have suffered. And the SEC's over-aggressive behavior, and this expert, who, by the way, appeared in the case that I was involved in, this last case, where he was impeached. His name is Harris DeVore. He was impeached in this case. The judge in this case, this Accelera, a very complicated case involving very complicated accounting issues. The judge basically, Harris DeVore came before the court, and he was impeached so badly the judge didn't rely on his opinion as an expert in a very complex accounting matter. So what did the judge do? The judge made himself an expert. Now, I don't know how a judge can make himself an expert in accounting. I'm not an expert as an attorney. So if you read this opinion, which I hope you did, Counselor, you would see that the judge made himself an expert in accounting. Well, if the judge made himself an expert in accounting, why did we not have an opportunity to cross-examine him when he had no expert? So this case, in my opinion, is never going to make it anywhere at all. The government has spent millions and millions of dollars, like, $5-10 million putting this firm Anton and Shai out of business and killing 100 jobs. That case is never going to make it in a million years. And if you talk to people, I talked to all these different SEC attorneys, and they told me that these courts are completely corrupt, the SEC courts. Every practicing SEC lawyer will tell you point blank that your chances of winning in the courts are almost nil. So here's a perfect example. You go into court, they spend millions of dollars blowing up a firm that has 100 people in it, issuing a press release before anything's proven. The day that press release was worked, 50 to 100 people were out of work that day. Bankrupted the owner of the company, and in the final analysis, they didn't even have an expert. So my lawyer told me that the only reason they ruled against us was because they spent so much money that they didn't want to get embarrassed. Isn't that nice? So the government can go spend $10 million, put people out of business, not have an expert, and then take the case and have the judge as an accounting expert. And then we're supposed to spend money that we don't have to defend ourselves against a government agency spending that kind of money. It's right in the decision. The expert was impeached. He couldn't rely on the expert. Period. He became the expert. Thank you for allowing me the opportunity to put forth my point of view on these things. So the question is, why should my license be reinstated? Well, I believe that if you can work and you have talent, which I apparently have in this field because I did it for 48 years. I did almost everything you could do in this field. I taught real estate taxation to CPAs. I signed audit opinions for 50 to 100 public companies with few, if any, sort of adjustments or changes at all. I've done everything you can do in this profession. So the easiest thing for me to do would be to walk away. You know, just say I'm 76 years old. I don't need to do this. I'll just walk away and let it go. But you know something? If people, when people behave like this, if you don't stand up and say what you need to say, whether it's here in the accountancy board or any place else, that's not the right thing to do. And if you're in good health and you can work, and you've been working for 48 years, and you've helped people like Tim Quintanilla, for instance, or like people in Anton and Shai, for instance, or for instance, 500 different companies and people that I've done work for over the years, and they need help and they call you up and you can't give it to them because you don't want to have to go in front of the accountancy board, or you don't want to have to do the difficult things that you have to do in life. I think that's immoral. As you can see, I'm in good shape. I can work. I'm strong. I'm honest. I want to make a contribution. I think it's a horrible thing not to work if you can do it. And that's why I'm here. Also, I have a history of mentoring young professionals. Some of them are partners in big firms right now. Some of them, I've worked in firms and I've mentored young professionals wonderfully, and I'm so happy when they do well. So I think I have an obligation, if I've got 48 years of experience, and this is an experience right here. This is a very valuable experience. So I would like to let them know what it's like to go in front of the California Board of Accountancy and what's expected of them. So if I just walk away and say I'm not interested in doing this anymore and that's all well and good, then those people will suffer. And when my day is done, I will not have done what I could do as a productive person. So I've worked for KPMG, one of the biggest accounting firms in the world. I worked for the SEC. I worked for the AICPA. I don't know anybody that has this experience that I have. I have over 45 years of diversified experience gained at the level of practice. If the board is generous enough and kind enough to reinstate my license, I don't know exactly what I would do with it right now. I don't know if anybody would ever hire me. I don't know if I'd ever get a client again. But if anybody would ask me to do the work and I had a license to do it, I would be able to do it. So I would feel personally comfortable that I morally did what I should do, that I just didn't walk away from the situation because it was difficult or it was hard, that I basically did what I felt I needed to do. And I also want the board to know that I take my responsibilities very, very seriously. And I'll strive to be as thoughtful as possible about the concerns the board has expressed. I think the biggest weaknesses that I have, because this has been a good exercise for me to look at myself and understand the weaknesses that I have that contributed to these things that took place. And I think the biggest weakness that I have is there's never been an investor that's lost any money because of my work. There's never been a client who has ever sued me in 48 years of practice, not once. So that tells you that I know what I'm doing and I'm careful and professional. But what I'm not good at, and if the board allows me to practice again, I'll make sure I'm good at, is I'm not that good at dealing with the regulators. Because I've gotten so used to practice, for 48 years I got used to practicing in such a fashion, and then all of a sudden there's a microscope that comes in, which is the PCOB and the SEC. And they look at, and there's a whole way of dealing with them. And the big firms, they know how to deal with them. The smaller firms don't know how to deal with them as much. They just don't. and the big firms do. And what the big firms do is they spend maybe 50 or 60% of their time documenting their work. And the bigger the firms are, the more time they spend documenting the work. Well, when you work in a smaller firm, you say, why are they spending all of this time documenting their work? Why don't they just do the work and get the numbers right and release the reports and be happy? Well, the reason they're doing that is they don't want to wipe in front of the California Board of Accountancy or the PCAOB. So my weakness is in documentation. That's where I come up short. And if, because of the fact that for all those years I worked in smaller firms, and then all of a sudden I found myself working in big firm work that was being done in smaller firms. So in order to give the PCAOB in order to give them the file that they want, which is what you have to do, so something like this doesn't ever happen again. In order to do that, there's certain things that you have to do in order to get that done. You need certain people in place and certain processes and procedures, and you need to document. Even this case with the SEC that's going on right now, the expert in that case said that had you documented your work better, you would not have been here. So if we had written down, because they didn't think we knew what we were doing, because we didn't write it down. So what he was saying basically, if when I opened up the work papers, if I saw all your reasons behind the things that you did in this case, you wouldn't even be here now. So as far as remediation is concerned, I think that's the crux of it comes down to that. The crux of it is that it's not enough to do the work correctly. That's not enough. If you do this kind of work, if you ever do SEC work, you have to do it in a firm that's geared up to do it, that has the resources to do it, and you just have to allocate 50%, just like the big firms do. Otherwise, the PCAOB will come in and they won't be happy with your work. You have to take 50% and just document everything that you do. Because if it isn't, and not only do you have to document everything that you do, but you have to document it at the time that you do it, not 45 days later, but right then and there. So the board can rest assured that if I ever have the opportunity to do the work again, I don't know whether I ever will or not, that before anything gets signed, before anything goes out, I will have a complete file with all relevant documentation in it. And that's pretty much what I think I've learned from this whole experience. Because had that been done in any of these instances, I wouldn't be sitting here today. That's what I think. That's my responsibility, and that's where I came up short. That's a lot to say.
All right. Thank you, Mr. Deutschman. Mr. Dakar, before you begin questioning of petitioner, why don't we address the exhibit that he seeks to have admitted? What exactly is it?
Would you like me to give my interpretation of it? Well, the first page looks like two different documents that were put together and photocopied.
Let me show you. I think this is basically it.
Yeah, I object because I don't understand where this document came from. I'm not familiar with it, and it doesn't indicate its authorship or source anywhere on the document other than the first page, but this doesn't seem to be from a continuous document.
Mr. Deutschman, what exactly is the document?
This document is, Charles Hall is a practicing CPA and certified fraud examiner. For the last 30 years, he has primarily audited government, nonprofits, and small businesses. He is the author of the Little Book of Local Government Fraud Prevention and Preparation of Financial Statements and Compilation Engagements. He frequently speaks at continuing education events. Charles is the quality control partner for McNair, McLemore, Middlebrooks and Company, where he provides daily audit and accounting assistance to over 65 CPAs.
So, Mr. Deutschman, I'm sorry for the interruption, but Can you tell me why you want the board to consider this document?
Because I think this man is an expert in work paper preparation and presentation. An expert, 65. And the problem in the Kabani case was that the PCAOB was not satisfied with our work paper documentation. So the remediation that I've offered to the board involves around certain procedures that I feel would have prevented this from happening, or if I had the opportunity to practice again, would prevent this from ever happening again. And this man has more experience in this than most people do. And when I read through this, I agreed with him exactly on what he had to say. And his fourth issue in here, which I wanted to make sure the board had, number 4, it says audit program steps should be signed off as the work is performed.
Mr. Jakar?
And that's important because you see the PCAOB has
Deutsch.
this 45-day rule.
Hold on, Mr. Deutsch.
Okay.
Mr. Dakar?
Yeah.
I just don't see the indicia of authenticity that these pages, I don't know where they come from. And so without that author here to testify about this, it would only be administrative hearsay, but it just doesn't even look like a reliable document that would be used as a reference in a serious matter like this.
So your objection then is lack of foundation?
Yes.
All right. So, Mr. Deutschman, I tend to agree with Mr. Dakar, but I do think that you've testified at length about the remedial steps you would take if given your license. It sounds like what you would do is in accordance with what's in that document, but without a proper foundation, I'm going to sustain the objections.
That's fine.
It will not be admitted into the record, but you have testified at length
That's
as
fine.
to what your steps would be, okay?
That's
Mr. Dakar, questions for Mr. Deutschman?
Yeah, Mr. Deutschman, you said that in the PCAOB discipline stemming from the 2008 inspection that your failing was that you didn't stop Mr. Kabani from doing what he did. But what I'm unclear on is whether you admit having violated any PCAOB rules yourself with respect to the work papers that were inspected by the PCAOB in 2008.
Well, basically, all I can say is that I didn't change anything and I didn't ask anybody else to change anything.
Did you participate in a program to alter audit work papers before they were inspected by the PCAOB?
Well, you know, it's a long time ago when this thing happened, and I wasn't in control of this process. So I can't really answer that question if other people were doing things unbeknownst to me.
Do you understand that this board previously determined that you did participate in that effort to alter the audit work papers?
Yeah, I understand what they did and that they felt that, but I wasn't, it's exactly what this administrative law judge said. And he spent weeks on this case, and he came to the conclusion that my culpability in this was that I didn't talk Mr. Kabani out of doing whatever he did, and that his basic take on my responsibility was 2 years and a fine, which I paid, and it happened 15 years ago.
Can you point to anything specific that you've done to rehabilitate yourself and prepare yourself to re-enter the profession since your license was revoked in 2019?
Yeah, I think as I pointed out before, I've been spending the last 3 years taking care of somebody who's been dying. That's a 24-hour-a-day thing that you have to do. I've been changing diapers. I've been picking people off the floor. I mean, I haven't had time to do anything. The last year I have time to do absolutely nothing. But as far as as rehabilitation, I've been as thoughtful as I can in regard to these matters so that they wouldn't happen again. And that's the problem, that things like this would not happen again. So as far as the Kobani matter is concerned, I wouldn't work in a firm that didn't have the proper controls, and I wasn't convinced that they were doing things exactly in the fashion that the PCOB wanted. I wouldn't work for a firm like that. I wouldn't care what the firm was. I wouldn't care. You know, big firms have gotten sanctioned like this too. KPMG's gotten sanctioned. They've had problems. I just wouldn't want to work there. That's all. It's really simple. I wouldn't work in a firm like that, because what basically happens is that if the controls aren't there, then, you know, good luck. So as far as rehabilitation is concerned, the board can rest assured that I would never work in a firm that didn't have the controls to make sure the work papers were done properly. I wouldn't want to work in a firm where I wasn't completely comfortable with all the partners were. And furthermore, and more importantly, I wouldn't want to work in a firm where I was a partner and didn't own any of it. Because if you're working in a firm where you are an employee and have no say in what happens in a firm, it puts you in a very difficult position basically to do anything. So I guess, and that's the way most firms operate. Most firms, Kobani Company had one guy and he owned 100% of the firm and he ran it any way he wanted to run it. Well, that's fine. But most accounting firms don't function like that. They have a number of partners and the partners meet together and they decide what they're going to do. So I wouldn't work in a firm unless it had that sort of a scenario, because I would never want to go through anything like this again.
No more questions, Your Honor?
All right, thank you, sir. We will now open it up to questions from the board, starting with Ms. Farrell-Hines.
For the record, it's merely Hines. It's not hyphenated. My last name is Hines.
Oh, okay. Sorry.
And I have no questions.
All right. Ms. Owens? No questions?
Ms. Owens has excused herself from the meeting. We believed we needed her for quorum due to the rule of necessity, but since we do not need her for quorum, she excused herself.
Understood. Ms. Waka?
Yes, thank you, Judge. Mr. Deutschman, you said multiple times that you accept responsibility for not, talking Mr. Kobani out of the cleanup process or having a lack of documentation, but you were noted as the concurring partner on those audits, which means you had to sign those work papers and make sure that the audit was done according to the PCOB standards. So do you not acknowledge that?
I acknowledge the fact that this is what I acknowledge. The fact that the work, so in other words, when the PCOB came in, and just bear with me if you can, please. When the PCOB came in, they have a different perspective than maybe other people do. Our primary responsibility was to make sure that the investors were protected and the financial statements were audited properly, right? That's the main thing that you have to do. When you sign an audit opinion, that's what basically you have to do. So I was always comfortable in that firm. It was a very good firm. And Mr. Kobani was maybe the best accountant I ever worked with. He was great. He got all the stuff right. Technically, he was terrific. He ran a good firm. But so I always knew that the work was being done well. Always knew it. So if you looked at a financial statement and you saw receivables, I always knew that the receivables were ordered properly. If you looked at the financial statements and you saw cash, it said there was $6 million in cash. I knew there was $6 million there. So no one ever questioned the financial work that was there. So I knew when I went to work in that place that those financial statements were right. I wouldn't have worked with them if the financial statements were right. But as far as the documentation in the files for the work that we did, not that the work was done, the work was always done. Always done. Now, whether it was documented at the time that the work took place or in this magic number of 45 days that happens later, in other words, the PCAOB said, it's okay. You want to go ahead and do some audit work, you do it now, but you don't have to record it until 45 days later, you know. But if it's 46 days or 47 days, that's no good. As far as that's concerned, that's where the firm came up short. That's where the firm came up short. And to fix that, it's impossible to deal with that unless you just have I know this for a fact after going through all of this. So if you're interested in remediation, believe me, I'm remediated, you know, because I know what happens when you don't document the work when it's done right then and there. Now, we have lots of professional people here, and all of us have experienced this. If you do work, and then a week or two later, you go back and you try to document what you've done, or it's 45 days later, or something like that, it just doesn't work well. It's like when people record their time and they try to do billing at the end of a month or something. Well, if you sit there and every time you're doing something, you write down your 1/10 of an hour, your half hour, whatever it is, it's fine. It doesn't take you that long to do it. But if you wait another week and you get to the end of the week and you have to do billings and send them out and all that sort of thing, then it doesn't work well. It's the same thing with this work. That's the best answer I can give you. I hope it's sufficient.
No further questions.
Thank you. Ms. Corrigan?
Your Honor, this
Thank you,
is
Your Honor.
Dan
No
Jacobson. May I please have a 1-minute break, biological break?
Sure, that's fine.
Thank you very much. Your
All
Honor,
right.
I have returned and I thank you.
All right, let's go back on record. All right, we're back on record before the California Board of Accountancy in the matter of the petition for reinstatement by Michael Deutschman. Ms. Corrigan, questions for Mr. Deutschman?
Thank you, Your Honor. I have no questions.
All right, thank you. Mr. Savoy?
Okay. I appreciate your being here, and I know this is not easy for you, but I have a number of questions.
Good.
Yeah. How are you supporting yourself today?
On Social Security?
Somewhere in here I read you were a partner in the Cabani firm, but you're saying you own zero ownership. How can you call yourself a partner there, not owning anything?
You can do that in the accounting profession. You can be an employee and you could assume some responsibilities, I suppose, but you don't own any of the firm.
You talked about 48 years of exemplary performance, knowledge, an expert in certain aspects of accounting. What I'm having trouble reconciling, and maybe you can help me, is somebody with that record. How would you allow yourself to get involved with these two firms that have come before the SEC in a very negative way?
I think that's a good question. I think it's a good question, but I think that it's sort of like, we've all had jobs in our life, you know, different jobs, I think, that we've signed on for, whether it be in accounting or whatever, you know. And you really don't know exactly what a job is like until you get involved in it. And once you get involved in a job, it's a difficult decision to make, whether you stay in the job or you leave the job or you look for another job, or whatever. But what I think you get to the crux of it, though. It's a good question, because I'll tell you why I really stayed in these firms, you know, because I love the work. Now, if you love accounting, which not a lot of people do, but if you love technical accounting, the highest level of technical accounting is SEC work. That's the highest level. So what I did was I worked for the American Institute as a technical writer. I was basically a real estate accountant in New York. I had real estate accounts, and I decided at some point in time I didn't want to practice like that anymore. So I opened up an ad in the New York Times, and the AICPA wanted a technical writer. And when they wanted a technical writer, they hired me because I write well for an accountant. And then after I did that, it's kind of brought me back to when I worked for KPMG, and all of a sudden they wanted me to write guidance for real estate accounting because they didn't have anybody that understood it very well. So I wrote all their guides for real estate accounting at the AICPA, which was published 25 years ago. It's got my signature on it. And after that happened, they had me, I was good, better than I thought I was going to be. After I did that, they had me update the accounting and audit guides, which are United States GAAP. That's basically the law for accountants. So I did all of that. After I did that, they sent me over to write the risk alert, which is also United States GAAP, for the real estate industry. And all the partners from the big firms are there. And I was the technical writer, and I wrote it, and I did a really good job on that. And I listened to them, and what they told me was that in these real estate companies were investing in all these subprime loans. So the risk alert basically said that you have to alert the accounting profession to the fact that they have to take a really good look at these loans and write them down. So I wrote it just like they told me to write it, you know. That's the risk alert. It's a document that gets issued. I assume it still gets issued. Gets issued every year by the American Institute. Gets distributed to all the firms. And I wrote that in about 1999. And sure enough, I wrote it right on the money because like it was when those financial collapses started to take place. So if you took a look at the financial statements, had those write-offs taken place, you know, maybe the banks wouldn't have had as much problems as they had. And that went out. So what happened after that was, I guess the SEC maybe saw this or something. I was maybe about 50 years old then. And all of a sudden, I was in Washington, D.C. in 2000, right around 2000, when all of those .com internet deals were coming through from Goldman Sachs, all that kind of stuff. And they had me working on reviewing the accounting, you know, for those kinds of things. And from there, when I was finished from there, I wound up working in smaller firms that did SEC work because the bigger firms weren't interested in hiring somebody. I love the work. That's really what it comes down to. I love this work. I have a gift for it, and I love doing it, you know. So I wanted to do it. When I was a kid, I wanted to go back and I wanted to do it again. And the talent was coming out again because I was writing these things and I was seeing it and it was happening again. So I started working. The big firms don't want you when you're 50 years old and you can't work 3,000 hours a year, you know. But I love the work. And it would find me because the expertise is so hard to get, you know. But I wasn't that good at it yet because you need about 10 or 15 years of experience before you can sign an audit opinion. Good enough to be an expert in that case where Tim Quintanilla kept his license, you know. I wasn't that good yet. So I just started working in smaller firms that did this kind of work. It's not like they didn't have the resources that you would have in a big firm, but I love the work. So anytime I would find a firm that did a lot of this work, I was happy to do it because I get up in the morning and I was doing the work that I really loved doing and was really cut out to do. So basically, when I found myself at Cabani, it was like a smorgasbord of every conceivable public company work that you could see. So if you love doing like public company work, everything was there. Companies in China, companies even in Russia, companies all around the world with all of these incredibly interesting accounting issues that you had to deal with. So I love the work because I finally had a chance to do all of it. So if you were like in a big firm like Deloitte or something like that, you might have like 3 clients that you could work on or something, and that's it. And they would pay all these big fees, and you'd have 10 or 15 people working for you, and they'd be dotting the I's, crossing the T's, and you'd be billing them $5 million, you know. But this was really satisfying. There was so much work, so much different kind of work, and he was so good at it, so he was always getting it right. He was always getting the work right. So when you picked up the financial statements, if you pick up a financial statements for a public company and you saw it, we were right on the money. The work, the documentation, as has been pointed out, was needed improvement. No question about it. So, but as far as the accounting work, the United States GAAP, how you account for issues, it was just the most interesting work.
Thank you. No more questions.
Yeah.
Thank you. Mr. Rosenbaum?
Yes, briefly. Again, thank you. Thank you for your comments. And I don't want to get any more about the need for documentation. I think you've made that clear and what should be done. My question, though, really goes back to your acknowledgement of your own efforts, culpability, you know, in the case before us here. One of the questions that you'd answered about whether or not you were the concurring partner and therefore should have signed off and known what was in the work papers or not, you know, you indicated that you just knew that things were correct. And as you've pointed out, that's not really the way the PCAOB operates. That's not really the way you document work papers. But you pointed most particularly, and we've talked about this, I think, already, you've indicated, and I don't know whether that's true or not, but the only culpability that the ALJ said that you had was that you didn't dissuade someone from doing something improper. And if that's the case, you would have known they were doing something improper. And so the question that I have for you is, did you know what was going on? Did you personally have an idea that the work papers were being changed in advance of the PCAOB visit?
I wasn't comfortable with what was going on in the firm.
That's not my question.
Okay, but let me.
That's not my question.
I'll answer it if you give me a chance. I will. I wasn't comfortable with what was going on in the firm, and I didn't know exactly what was being done, and I still don't.
That doesn't explain how the ALJ would have said that your culpability is failure to dissuade someone. How could you dissuade someone from doing something if you didn't know what was going on?
Well, I think dissuade somebody from the manner in which he presented things and the manner in which he ran the firm, because and this is really gets to the crux of the issue. Basically, is that if you do things, if you have steps and procedures and a way of doing things, and you stay in that box, then that's where you need to be. And that's
I don't disagree with that. So so I guess, are you saying then that the firm operated sort of loosely and you weren't comfortable with other actions that the firm was doing?
What I'm saying is that the work was good. In other words, I knew that the financial statements were good. If someone relied on a financial statement, they had a good set of financial statements. It's important. It's an important point, and I'm not in any way taking your question lightly or anything like that. I'm just explaining my point of view if I can.
But you're saying that you knew the work was good. How did you know it was good when you say you've got concerns about the way things were done?
The reason I knew the work was good was because I was there every day. And so in other words, I was there every day. And if the work was basically getting done every single day. So in other words, let's say you have like a bank account, right? And you send out confirmations and you have tick marks on the bank account. And it says that there's $6 million in the bank. I knew there was $6 million in the bank. Or if you have receivables and it said there were like $2.5 million of receivables there. I knew that we had coverage on the receivables. What I wasn't comfortable with was the level of documentation of the procedures that had in fact been performed.
Okay, let me ask you this question one more time.
Okay.
Did you know that the work papers were being changed prior to the PCAOB's visit?
I didn't know that.
Okay, that's all I have.
All right, thank you. Ms. Ward?
I have no questions.
All right. Mr. Jacobson?
Thank you, Your Honor. Mr. Dakar, I note in the petitioner's papers that although he doesn't reference it, name it. The name of the case is Jarksy versus the SEC out of the Fifth Circuit Court of Appeals, and there's apparently some, according to the Fifth Circuit, some infirmity with the SEC's constitutional infirmity with the SEC's administrative courts. Does that have anything to do with this case?
It does.
And what is that?
Well, there's a case before the Supreme. That case is before the Supreme Court right now, and it was. I'm not trying to be a lawyer, so just kind of like put up with me, okay? But what's basically happening, as far as I can understand, is that the Supreme Court, the way it's currently constituted, has issues with some of the powers that administrative courts have in the federal government. So there's an FTC case that came down, and then there was another case, which is a big case that involved millions of dollars, and the FTC has one administrative law judge, and that's it. And based on that, they can go ahead and fine companies whatever they like and do that sort of thing. And what the Supreme Court did was they also took another case, which is this case that you refer to, and they dovetailed it with that case. And they're going to hear both of those cases. They already heard the cases already, and they're going to make a decision. I guess the consensus is they're going to make a decision in, not a decision, they're going to issue a written judgment around June as to how those cases are going to come down. And once again, I feel uncomfortable talking about this because I'm not a lawyer, but the little I know about it is that if they could rule, they've done it before, they could rule this unconstitutional, those courts unconstitutional. And if they did that, this case, the Anton and Chai case, I think would basically be ineffectual. There would be no case. It would be thrown out because they would basically say that the courts are invalid. Or,
go ahead.
Yeah, that's my understanding of it.
Thank you. Mr. Dakar, does the Jarksy case currently have any effect here in the Ninth Circuit?
Mr. Jacobson, I don't know the answer to that.
Okay, thank you very much. On the petition, MD-PET-015, sir, you say, based on my involvement, Mr., and then it's redacted, kept his license and paid a fine of roughly $100,000 that was covered by insurance. How do you know that?
That's what the lawyer told me.
Which lawyer?
John Armstrong,
Who did he represent?
Tim Quintanilla.
And did he say what type of insurance paid a fine?
I assume it was, typical insurance firms that accountants have, malpractice insurance, I suppose.
Did he say anything about the word damages?
I don't know about that.
Thank you. At SP-PET 009, sir, there is a place for you to sign under the penalty of perjury and date the signature. What I have is not signed or dated. Why did you not sign it or date it?
I thought I had. I'm happy to sign it now or whatever. I think I signed it, didn't I?
Mr. Descartes, do you
I
know
recall signing the
if
petition.
there's an original that is signed and dated?
I signed it. Yeah, here's my signature right here. Yeah. That's my signature, right? Yeah, it's signed.
Is that on page 9, PET 009?
If I might interrupt, Mr. Jacobson, I think you
Please.
might be looking at the wrong set of papers. The page 14. Yeah, page 014 MD-PET 014. It appears that it has been signed by Mr. Deutschman.
Thank you, sir. I apologize. Your Honor, I have no further questions.
All right, thank you. Ms. Salazar?
Thank you, Judge. I would just mention, Mr. Deutschman, condolences on your loss, and I have no further questions.
All right. Mr. Descartes, any further questions?
No, Your Honor.
All right. And Mr. Deutschman, I am going to turn the floor back over to you one final time. Is there anything more that you want the board to consider?
I think I want to thank the board for allowing me the opportunity to come here and to extending the courtesies and the resources of the state of California. This is very impressive to me that I have this opportunity to come before everybody and put forth my point of view. I have enormous respect for everybody here and for the fact that I've had this opportunity. This is a wonderful opportunity to have. It's something I'm going to cherish. And I can't thank you enough for giving me the opportunity to be here today.
Are there any final questions from the board? All right. So, Mr. Deutschman, as I said earlier, the board will go into closed session to deliberate. You'll receive notice of the decision at a date in the future. Exhibits 1 through 14 and Exhibit A are admitted in evidence. With that, the matter is submitted. The record is closed, and we are off the record in this matter.
Thank you, Your Honor.
Thank you. Does the board wish to take a recess before moving to the next case? All right. Is 10 minutes enough? Come back at 3:15? All right. Thank you. All right. It looks like we have everybody back. Ready to proceed? All right. Let's go ahead and go on record. We are on the record before the California Board of Accountancy, State of California, and the matter of the petition for reinstatement of revoked certificate by Stephen Pybram. This is Office of Administrative Hearings, case number 2022-100020. We have already established off record that there is a quorum of board members present, but just for our record, I will ask the board members to identify themselves, starting with the board member furthest to my left.
Sorry, Carrie Ann Farrell Hines.
Dee Dee Owens.
Christian Lotta.
Nancy Corrigan.
Michael Savoy.
Joe Rosenbaum.
Evangeline Ward.
I'm Dan
And
Jacobson,
our
appearing remotely from Tustin.
And Katrina Salazar. Thank you.
Ms. Salazar, I think you might have been on mute or it broke out.
And Ms. Salazar, present. Thank you.
All right, thank you. May I take the appearance of the Deputy Attorney General?
Yes, Deputy Attorney General Ted Durkar.
And Mr. Pybram is present, and you are representing yourself, sir, correct?
Yes, sir.
All right. So as we discussed off record, Mr. Pybram, I know you sat through the last hearing as well. Mr. Durkar will present your petition. In this matter, he'll then give an overview of your case. You'll then have the opportunity to testify under oath, after which Mr. Durkar and the members of the board may have some questions for you, okay?
Okay, very well.
If you have any questions during the proceeding, let me know. Like I said in the last hearing, I can't give you legal advice, but I may be able to explain why we're following certain procedures, okay?
Okay.
All right. Mr. Durkar, are you prepared to go forward?
Yes, Your Honor.
All right.
I'm appearing in this matter on behalf of the people of the state of California by authority of Business and Professions Code Section 5115 and Government Code Section 11522 on this petition for reinstatement by Stephen Pybram. My role here is to assist the board members and Your Honor in fact-finding. My role is not adversarial, but is intended to protect the public health, safety, and welfare. I'm here to ensure that the board and Your Honor have the information needed to make a reasoned decision. And I would like to go ahead and introduce the evidence into the record at this time. All the board members, the petitioner, and Your Honor have been provided with a copy of the same documents. There are a total of 46 pages, which have been sequentially marked, starting with SP-PET-001. And the notice of hearing is at page 43. The petitions at pages 5 to 16. I would like to start by marking this and having it entered into evidence, and I believe it's going to be broken down into separate exhibits, Your Honor.
All right. So with regard to the exhibits that are listed on the face page of the packet, I am prepared just to mark them as you have numerically, starting with Exhibit 1, the petition for reinstatement of revoked license or certificate. Exhibit 2 is the proposed decision and decision in order. And just for clarity's sake, for the record, Exhibit 1 consists of 23 pages, date stamp 1 through 23. Exhibit 2 is the proposed decision and decision in order. That's pages 24 through 31 of the packet. The accusation is pages 32 through 39. License history, which is Exhibit 4, the accusation being Exhibit 3. Exhibit 4, license history, pages 40 through 42. And Exhibit 5, the notice of hearing, as you said, that is pages 43 through 46. Are you offering all 5 into evidence at this time?
Yes, Your Honor.
All right. Mr. Pybram, we'll take them one at a time. Exhibit 1 is your petition. Any objection to the board receiving that in evidence?
No, Your Honor.
All right. Exhibit 2, proposed decision, decision in order. Any objection to that exhibit?
No.
All right. Exhibit 3, the accusation. Any objection?
No.
Exhibit 4, your license history. Any objection?
No.
And Exhibit 5, notice of hearing. Any objection?
No.
All right. With that, Exhibits 1, 2, 3, 4, and 5 are admitted for all purposes. Mr. Durkar.
Your Honor, I'd like to provide a summary of the case.
Please do.
Mr. Pybram received his CPA certificate number 31088 in 1980, and that license history is at pages 40 to 42, Exhibit 4. Now I'd like to provide a background of the facts pertaining to Mr. Pybram's discipline. In 2012, a jury found Mr. Pybram guilty of 4 felony counts of willfully making and subscribing to a false federal income tax return. In 2013, he was sentenced to 36 months in prison, followed by 1 year of supervised probation. The CBA's accusation followed that conviction, and it charged him with 5 causes for discipline. First, conviction of a substantially related crime. Second, dishonesty and fraud. Third, fiscal dishonesty. Fourth, knowing preparation of false financial information. And fifth, willful violation of the Accountancy Act. The accusation also sought to revoke the license of his accounting firm. Mr. Pybram defended his administrative case, and it went to hearing in September 2016 before an administrative law judge. Mr. Pybram was on criminal probation at that time after having served his prison time. The ALJ's proposed decision called for revocation of the licenses of both Mr. Pybram and his firm, and the board adopted that decision effective December 2016. The board's decision sustained all 5 of the disciplinary charges, and it imposed a cost bill of $7,730 due upon reinstatement if that occurs. Mr. Pybram has paid a small amount of that. He's paid $225 of the cost so far. This board's decision, it's at pages 26 to 31 of the materials. And let's see, yes, that's Exhibit 2. The decision lays out the facts that the false tax returns were Mr. Pybram's own income tax returns for the years 1999 to 2002. What he had done was he'd engaged in a sophisticated scheme to avoid paying tax on the income he earned from accounting services. In 1998, he created a 501c3 charity called the Foundation for Harmony and Happiness with the stated purpose of helping married couples with relationship and financial issues. He used this charity to hide nearly all of his accounting income. He falsely characterized his work income as gifts, grants, and contributions to the foundation. Once the scheme was established, his income went from over $200,000 in 1998 to a reported loss of $33,000 in 1999. In the following 3 years, his returns reported low incomes of between $11,000 and $27,000 per year. At page 31 of your packet, this board's decision states that Mr. Pybram has not accepted responsibility for his criminal conduct. His testimony that he was not aware that his conduct was wrong is simply not credible. In his defense, Mr. Pybram had claimed that he told the IRS that his charitable foundation would do tax preparation for individuals and corporations. Thus, his actions were justified because if the IRS had had a problem with that, they would have notified him. This board's decision found that this testimony lacked credibility. I'll make some observations now and summarize Mr. Pybram's petition. In the petition form, Exhibit 1, page 7 of your materials, where it asks the reason for discipline, Mr. Pybram disclosed his conviction for 4 years of false tax returns, but he also wrote, this did not harm a client or member of the general public. In 2012, IRS made an arbitrary allocation of corporate income to Form 1040. Further on, in response to question number 11 in the petition form, which asks about the work he'll do if his petition is granted, Mr. Pybram states that he plans to prepare tax returns. Mr. Pybram attached a 4-page narrative to his petition, and that starts, I believe, at page 13 of your materials. It starts off with a paragraph that says, "To the board, it is with a great deal of respect that I approach this board. It troubles me that the board has not considered what actually happened in reality, but instead the board is acting on twisted truths passed on by an overzealous prosecutor whose ambition in life is to destroy the professional life of a very talented professional." The next paragraph is then titled Acceptance of Responsibility. And in this paragraph, Mr. Pybram claims that he takes full responsibility for the actions that led to his conviction. Then he goes on to describe the foundation, the charitable foundation that he created, and how he still believes that his treatment of income for accounting services was legitimate. At page 15, he wrote the following. So this is the 3rd page of his narrative. "I submit that I was a hardworking professional pursuing a national cause and educating the public about financial planning, marital communications, and financial literacy." He also wrote, This is not the case of some wacko CPA trying to come up with a new method to beat the tax system. This is the case of a hardworking, honest, talented, squeaky clean professional being abused by the system after achieving success on television. He had detailed elsewhere in his petition that he wrote books and that he was a frequent speaker and guest on radio and TV programs. That's what he was referring to. At page 16, which is the final page, the final page of his narrative, he explains that his criminal case was based upon allegations that his foundation was formed for an improper purpose and was a sham. He writes, I make no excuses for the conviction, but then says that the prosecution won because of a clever argument to the jury, and that what happened to him is an example of bad things happening to good people. He closes the narrative by saying that he left his personal opinions out of the narrative, that he takes full responsibility for what happened, and that he does not look for anyone to blame. Mr. Pybram, along with his petition, also submitted a table at page 17, which references about 180 hours of CPE courses with dates from 2016 to 2021, but he did not submit any course completion certificates. So this claimed CPE, while significant in terms of the number of hours, it is undocumented. Mr. Pybram also submitted three one-paragraph character affidavits, all signed in 2020. The first, which is at page 18 of your materials, is from an attorney, Stephen Penner, who attests to Mr. Pybram's skill and character. This attorney says that he's known Mr. Pybram for over 20 years and that Mr. Pybram's money and marriage books have been helpful to him in his divorce law practice. He also says that, quote, it was shocking to learn of the IRS attack on Mr. Pybram, unquote. The second affidavit is also from an attorney, Jeremy Purvis, who is an associate attorney to the first affiant, Stephen Penner. Mr. Purvis says that he knew Mr. Pybram for 4 years at the time of the affidavit, and that based on his consultations with Mr. Pybram about legal and tax issues, I guess on cases that he was handling, he praised Mr. Pybram's skill as a tax accountant and financial planner. The third affidavit is from a Bill Bogue of Vineyard Irrigation Systems. He said that he knew Mr. Pybram for 38 years. He praises Mr. Pybram's demeanor and professionalism, and he says that Mr. Pybram has been employed by his company since 2016, but he did not state in what capacity. All three affidavits praised Mr. Pybram for personal and professional strengths, but none of them described any form of rehabilitation. And other than the reference to the IRS action being shocking by the first affiant, none of them disclosed the misconduct or explain how he has reformed. That concludes my summary of the case. Mr. Pybram has the burden of proof, and once his presentation is done, I will have some questions for him.
All right. Mr. Pybram, are you prepared to testify?
Yes.
Would you please raise your right hand, sir? Do you solemnly swear or affirm under penalty of perjury the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. At this point, Mr. Pybram, this is your opportunity to tell the board what you believe the board needs to hear to decide the case fairly. So I will turn the floor over to you.
Okay, very good. Thank you. I had included with the petition for reinstatement a narrative that pretty well describes the facts in the particular case. So I'm not going to hash over that, but be willing to take any and all questions related to that. Just as an overview, in 1980 was issued a CPA certificate. 2016, it was revoked. So over 30 years of good practice, absent the IRS debacle, I had no infractions and no problems related to dealing with clients or in any kind of law enforcement infractions either. In approximately 1980, I set out as a syndicated, not only as a CPA in practice, but also wrote various articles as a syndicated columnist.
These articles were published in national newspapers and magazines under the title of Business Sense, CENTS, and Agribusiness Tax Tips. Agribusiness Tax Tips was popular in many weekly publications that were kind of in the central farming belt of the country. Writing those articles led me to want to write a book. I was searching for what to write about and was setting forth to write about family financial planning. Upon interaction with other authors, I came up with the idea of money and marriage, took a look at the factors involved in money and marriage, searched what marriage counselors, psychologists, psychiatrists study with regard to the number one cause of divorce in the United States, and found no books, no treatise. There was no reference material at all on how to deal with this problem. I looked to financial planning, which I had already a pretty good well and resource of financial planning information. Had attended a number of AICPA courses with regard to financial planning, and set forth to write the book, carefully stitching together the ideas and thoughts of professionals related to marriage counseling and the ideas and thoughts of professionals related to financial planning. The book is kind of first was laid out technically and then reduced into plain English so that people in the general public could understand. The books are two books: Money and Marriage, Making It Work Together, Money and Marriage for Engaged Couples. So this travels the universe of what people might encounter when they're married and how to deal with the number one cause of divorce, and that's the financial squabbling that goes on within a marriage. And the other book is about if you're thinking about getting married, what questions you should ask or what things you should know about your spouse. And it goes into describing the choosing process that one should consider and go through before deciding upon latching on to a partner for a lifetime. So in writing these books in 1996, they were the first book was released, Money and Marriage, Making It Work Together. Upon release, it got pretty immediate media attention. People were interested in the topic. By 1998, things were rolling forward, and the book and its popularity were growing. I was a member at the time of the National Speakers Association, NSA, and in the NSA organization, there were a number of people that were doing speaking and speaking events, and they were doing it in the nonprofit form. So I had spoken to a number of well-known national people that were doing this. I came back and had a conversation with a very skilled Los Angeles law firm that knew about the subject matter, and they assured me that what I set out to do could be covered through this nonprofit entity. The law firm formed the corporation. The law firm waited some period of time, made an application with IRS for nonprofit status. The application was submitted to the IRS, and a barrage of questions were asked back and forth over the course of 4 months. The questions were asked to the attorney and answered by him, and to the extent he wanted my input, he would contact me. So basically, the law firm went back and forth with the IRS. IRS was thorough in its questioning. IRS had a fairly clear idea of what I had set out to do, and the general idea of what was going to happen was books were going to sell, have seminars about the topic, and then leading into money and marriage clinics. So it is that the application for 501c3 status was written in such a way to consider all of these things. So the IRS carefully took a look, gave approval. Law firm says you're good to go. I thought it was good to go. I set forth then in 1999 to I was the sole proprietor, and then it formed into, the corporation began, I believe, in January of '99, and then that created a 1040 return for, in '98, the income was like 298,000, and then all of a sudden in '99 it went down to like 35,000. And so the government, in their case, I don't know that I had the best representation, but again, I'm taking full responsibility for what happened. It happened to me, and I'm very sorry for putting myself in that vulnerable position to be here today. But so here's what went on in leading to the conviction and the court hearing is IRS made hay over what happens to 40,000 corporations a year when they incorporate. Things change. The gross income goes to the corporation and it's not present in the individual return. And there's where the government spent a lot of time trying to be convincing that something was missing. So time went on that the IRS started their investigation in 2005. It ended its investigation in 2012. 7 years of investigating. No smoking gun, nothing. They called a line of witnesses. Yes, I work for Mr. Pybram, and see you later. So there was a line of witnesses without, 7 years of looking, no smoking gun. In October of 2012, I was convicted of 4 felony counts of filing a false tax return. And that came about by originally filing the return based on the facts and information I had at hand. Now, at that time, when I was preparing those returns, it was a situation that the IRS had audited 4 or 5 returns before that year. So let's say in '98, go back 4 years, those returns were all audited by the IRS. They were picking on my automobile usage, and they allowed the office in home deduction and picked on a little bit of travel. So it was repeat every year. So I knew the IRS was going to take a look at my tax return. So why on earth would anybody beyond the 3rd grade prepare a return that was false? I just don't. I'll go to my grave not knowing the answer to that question. I prepared the tax return the best I could, given the facts as I knew them, and given the permissions that the law firm gave. These returns were put on file 98, 99, 2000, 98 through 2002. Sorry, I lost that train of thought. Okay, so I put those returns on file through those years, 98 through 2002. It was 12 years later, IRS came back with an idea that these were false. And that was the first time I heard anything about it being false. I heard about something not right because in 2005, the IRS CID showed up in my office when I wasn't there. It is that through 2005, 2007, there was dialogue and talk between attorneys and the IRS attorney, and there was still no mention of what was wrong. So it was revealed what was wrong in 2012, which, just round numbers, is 12 years after I filed the return. Now they're calling them false, and then they won in court. So I can't say any more about that. I have some information about rehabilitation. I'll give that in a second. But I do, with respect, ask for reinstatement if you consider all the facts and surrounding circumstances. I'm sorry, sad, and remorseful. I've been punished for what I did. I've been punished for what happened. I chose the wrong entity, and I won't make this mistake again or put myself in even a vulnerable position to be questioned or found guilty of a crime. So going through the support for reinstatement, I'd like to put this into the record as an exhibit. Be happy to read the highlights if you'd like.
You've shown that to Mr. Dakar?
You prepared this? Yes.
Your Honor, I haven't had a chance to review it, but I don't object to it being admitted as a supplemental narrative from Mr. Pybram.
Is it just a narrative that he drafted?
Yes, it is.
All right. So with that, Mr. Pybram, do you have any other exhibits besides that one?
No.
All right. That'll be marked as exhibit.
Not at this time.
All right. That'll be marked as exhibit A.
Okay.
And described as supplemental narrative, and it will be admitted.
Okay. And anything else I was going to present is on that piece of paper that just left. So we may have to pause here for a second till I get it back.
Just so I'm clear, Mr. Dakar, are you categorizing that as administrative hearsay, or you have no objection to it being admitted for all purposes?
Well, I didn't have a chance to review the content, so I would just say administrative hearsay at this juncture.
All right. It'll be admitted as administrative hearsay.
Okay, I'll spend more time making it my testimony. Do you have any other documents? No. Okay, good. Not now. Okay, good. I'm realizing I should ask people before I even start around how they come here. It's I think it's on the floor. So, because this conference room is on the floor. copiers on there. She'll be back. Okay, thank you. Okay, ready to go. Okay, so taking into consideration reinstatement, basically from my reading in California, practically speaking, there's no such thing as permanent revoked license. So I would like to have the board consider returning my license if possible. Eligibility, as a general rule, is an individual can petition to reinstate their license if they're not on probation or parole and a requisite amount of time has passed. So I believe as to these factors, all of this has been accomplished in my case. Very simply put, these ingredients are adequate rehabilitation, both through personal improvement and the passage of adequate time without further incidents, and there have been no further incidents. Evidence of professional knowledge and competency. I have submitted a list of classes that I attended, but I, in 2016, 17, 18, had no idea I would have to keep the certificate of completion. So the education that I completed, the black and white for sure stuff is on the list. And I've taken a number of other courses as well that I didn't put on the list. So I'm in the camp of a firm believer in continuing professional education, and I do that myself every year. The demeanor and attitude of the person applying for reinstatement also is something that should be considered. And also the idea of second chance. So I'm going to make a plea at the end to this board to offer me forgiveness and to provide me, please, with a second chance. I have built a quality management consulting firm doing business today as Canberra Company. I'm an active member of society in Santa Barbara, the business community, and church. I present no particular harm to the public, and the underlying circumstances, the petitioner did no harm to the public or client. The conviction involved the petitioner, his personal tax return, and the IRS 12 years later, after filing said return, making allocations to change the original return. The petitioner has demonstrated his good character and good judgment and the recognition of right from wrong and the need to follow the law. Petitioner is a business leader in the field of money and marriage, that of preserving marriage, lowering the divorce rate, and contributing to improving financial literacy in the United States. The sufficiency of time has passed to accomplish reinstatement. The underlying issues are the years 1999 through 2002 in rounded numbers of 20 years. The conviction and punishment have been served and probation has been completed in 2016, which is over 6 years ago. The petitioner has a crime-free life. Prior to conviction, has had no trouble with the law or law enforcement, and after conviction, no trouble with the law or law enforcement. The petitioner has demonstrated has a demonstrated longevity and permanence of a positive lifestyle. Letters in support of reinstatement have been submitted with the petition for reinstatement. Petitioner has submitted a list of continuing education that the petitioner has participated in. The petitioner has not maintained a list of the other education that the petitioner has participated in since 2016. The petitioner is a supporter of continuous life learning and has taken courses beyond the list of courses presented with the petition in the fields related to tax law change, computers, technology, hospitality industry, small and medium-sized business, organizational management, and related subjects of marketing, advertising, and customer loyalty, and the power and operations of a POS system designed for the hospitality industry. Interrupted by the coronavirus, I have been a member, but not presently, but prior to Corona, was a member of the Santa Barbara, Oxnard, and Palm Springs Chamber of Commerce. The nature of the offense is a result of damage that petitioner did to himself, and there's no evidence of harm to a client, a member of the public, or anyone else. Petitioner presents no harm of any kind to consumers, the public, clients, or other members of society. Petitioner is deeply saddened, humbled, humiliated, remorseful for his participation in events that led up to the conviction. Petitioner accepts the conviction and is a strong believer in the justice system. Having been hurt, injured, and emotionally punished by the events leading to the conviction, petitioner has learned from this experience and has no intention to have any further brushes with the law. Petitioner believes that a sufficiency of evidence has been presented to support the reinstatement of his CPA license. With that, I have no further comment.
All right. Thank you, Mr. Pybram. Mr. Takar.
Yes. Thank you, Your Honor. Mr. Pybram, we've heard about the facts related to your conviction for tax fraud and about the books that you wrote, but something that I'd like you to tell the board about is the nature of your accounting work until your license was revoked. Could you tell us about your accounting career?
Well, mostly I had a tax practice, so I was mostly preparing individual and corporate tax returns.
And what work have you been doing since your CPA license was revoked?
I have primarily been the controller of a company called Pacific Ag Water.
And perhaps you've meant to bring this out in your testimony to this point, but could you explain what you believe you've done to rehabilitate yourself since you were convicted of tax fraud?
Hello? I think I read into the record this information which speaks directly to the point.
Okay, thank you. Have you done anything else to prepare yourself to re-enter the profession?
Such as?
I don't know. Did we have the CPE? Anything else that has prepared you for the work that you would plan to do?
Yes, again, that I think we can find no argument with the Spidell program, and that CTEC requires 20 hours a year of continuing education. So there's 28 there, and let's just say an hour a month. But I'm sure it's way more than that I've done through webinars and interactions with people over the internet. We were at 28 and gave another 12. So there's 40 hours right there without really digging too much into my records to find more. So I'm a believer in education. I like to be sharp and on the ball, and that I have not let down my guard with regard to each year participating in continuing professional education.
Now, your narrative attached to your petition repeatedly claims that you take responsibility for your actions, but I'm a little unclear about what it is you take responsibility. Do you take responsibility for any wrongdoing?
I did it. I did all of it. I did all the steps. I filed returns. The IRS came in, took a look. The IRS won in court. I'm guilty of a crime, and that I'm not defending or trying to back out of that. I tried to explain the surrounding facts and circumstances. It's just not some goofball made a mistake or tried to steer the numbers in the wrong direction. In my dealings with the IRS between 2005, someone's life was interrupted for 7 years during a federal investigation. This causes quite a bit of heartache and consternation in one's life. Nowhere along the line has there been 10 cents of revenue that the IRS said I did or didn't put in the return. There is no dispute about the revenue. The dispute is about whether the corporation should have existed or not. And then the IRS's idea was a novel one. I've not found yet a court case where they've been able to do this and walk in and take all the income from the corporation and throw it into your personal return. And they did it. So again, I'm not trying to wiggle out of it. I accept it. I did it. I signed the returns. The returns have been found to be incorrect. I was guilty. I am guilty of a crime. I served my punishment time, and I'm still serving my punishment time economically today.
Thank you, Mr. Pyram. Your Honor, those are all the questions I have.
All right, thank you. I'll now open it up to questions from the board. Ms. Hines?
Thank you for coming to appear before us today. Do you believe that the IRS correctly found that you improperly prepared your own tax returns and underpaid your taxes?
Well, it depends on how we want to speak about this. If we want to just speak openly about what happened, there's that situation. Or if we want to speak about what did happen, and I'm inclined to do that because we're in this professional environment. Here is, I filed tax returns in 1998 through 2002. The IRS inspected those returns. The IRS took information to a court of law. A jury found me guilty. That's the case.
Sure. The way in which the IRS interpreted the law regarding how those returns needed to be prepared, do you agree or disagree with the IRS's interpretation of the law?
Thank you for that question. The answer is no.
Thank you. And you stated that your intention, if you were to be reinstated, is to prepare tax returns on the behalf of clients that you had solicited. Is that correct?
Yes, correct.
Thank you. I have no further questions.
All right, thank you, Ms. Hines. Ms. Owens?
I have no questions this time.
All right, Ms. Lotta?
Your Honor, no questions.
All right, Ms. Corrigan?
Your Honor, no questions. Thank you.
Mr. Savoy?
Yes, I have quite a few questions.
Okay.
Whose initial idea was it to form this 501c3?
Well, I think where the seed came from is my membership in NSA, talking to other people that had incomes well over $1 million a year that were doing it in the 501c3 format. I took that information and I took it to a competent law firm and I said, tell me yes or no. They looked at it, they studied it, they said they could do it and it would allow me to do what I did do. And they wanted a retainer. So, you know, I heard about it. I went to an authoritative source to find out information, if it was at all doable, or could I do it, or could my facts and circumstances fit in the purview of that. And knowing that my plan was to do books, seminars, money and marriage clinics, it all puzzled together into the application for the 501c3 status. IRS did not just rubber stamp this thing. They went over this thing for 4 months with probably no less than 80 questions. The questions went back and forth and back and forth and back and forth. It was clear what was going to happen.
So you then took it upon yourself, based on the application being approved by the IRS,
Yes,
to file returns in that manner.
correct.
You filed those returns from 98 through what year as a 501c3?
2002.
But you said it took them until 2012 to come about and say to you, they changed their mind. That's not what you should have been doing. So why did you stop filing 501c3 tax returns in 2002 and not continue because that was your mode of operandi?
Yeah, good question. I think the 2003 return was filed, but I think IRS backed away from that because even in their calculation, it showed a net operating loss. So they didn't want to have that in the picture. And I think with 2004, it was going to be filed in 2005. But February 2005, two CDI guys shows up in my office, and they just really let loose with a lot of things to my employees that kind of rattled them. And I came back the next day to find out that this took place. So in speaking with the law firm, there were two law firms that represented me, one initially and then one followed up after that. So in speaking with the law firm that I was dealing with, they said, don't file any returns. Their situation was, don't file any returns till I tell you so. And that tell you so was in about 2007. They said you can go ahead and begin filing returns, but we did it based on the Schedule C format.
All right. It says in here that according to a forensic accountant that did some work, that the total amount of taxes that were owed is $7,700. Was that the conclusion
for 4 years
that the IRS came up with as well? And that is the basis for them calling them improper returns, was $7,700
for 4 years, divided by 4 is, let's just say, $2,000 a year.
So that's what you wound up paying them, plus penalties, plus interest, whatever. Well, I'm trying to differentiate between the $7,700 that the forensic accountant came up with,
right,
and what did the IRS come up with?
Okay, they didn't. Well, they did, but it was, I'll tell you that story if you want to hear it. Okay, the forensic accounting firm in Los Angeles, again, well-known CPA firm that does forensic accounting, took what was on the 501c3, that corporate return, and they put it on an 1120. I mean, every year, line for line, number for number, put it into 1120 format, and that's where these numbers come from.
Oh, but the IRS put it in a 1040, and they had completely different numbers.
Well, did you want to hear what IRS did?
Well, just give me a number because I'm trying to
okay.
Compare and contrast.
IRS told the court, if you will, that I owed $250,000 per year in taxes, and it's in this guy's records here. Over the 4 years, $250,000 per year. Year 1, 2, 250, 250, 250, 250. How they did that is they took my QuickBooks records, and there were accountants in my office that went over this. I was going to describe it as forensic accounting, but it was checking up on what the IRS did. So I had the good fortune of having employees in the office go over this thing. So we go down through Quicken, and like every 8th check is just disappeared from the record. Eight more checks disappeared. One disappeared. So they took Quicken, put it into their system, and magically made disappear a lot of expenses that made the taxable income go up. They said I owed $250,000 in tax for the 99 year when there was like $295,000 of gross revenue.
Oh, God.
And this was just made for a movie. The shenanigans that they did to come up with their number.
Yeah, I mean, the only thing you're guilty of is having a bad attorney. No more questions.
Mr. Rosenbaum?
Yes, the only question I would have is, I guess what the IRS did during your trial was to hold up the 1998, 1989 returns and show that there's a difference.
Yes.
What was the revenue source in 1989 for the 501c3?
Didn't start till 98.
Okay.
Or 1989.
Okay.
98 is when it started.
Yeah, I'm with you. I understand the question.
Okay.
So you have this guppy in the ocean, a small company trying to create and start a national money and marriage foundation. So the revenue that was in the return came mostly from the revenue from tax returns.
Okay.
That's just the bottom line. There was some book revenue in there as well. Had not had the chance to get underway. When IRS came in 2005, the attorneys say, stop, don't do anything.
No, I understand. I just had heard you say that the revenue was coming from speeches and clinics, and I thought I had read that it was actually coming from tax returns.
Right.
Okay. No further questions.
Ms. Ward?
I have no questions.
Thank you. Mr. Jacobson?
Thank you. Now, in your petition, Bates number SP-PET-009, there's a space for you to sign under the penalty of perjury and date it. And I don't see a signature or a date. Why didn't you?
I'm fairly certain I signed all of the documents.
Mr. Dakar, could you help me? If there's an original?
Mr. Jacobson, take a look at page 12.
It's on page 12.
I believe that Mr. Pybram did sign his petition under penalty of perjury at page 12. Is that what your records show, Mr. Jacobson?
It does. I was confused as to why there's two spots for it.
It may be a little confusing because it looks like there's a narrative answer that's interspersed on page 11.
Yeah, I can see where it would be fine. Sir, did you sue one or both of the law firms that were advising you about this issue?
That is a great question. I have been and was at the time economically disabled to do that. But yes, I think 3 law firms should have been served with some kind of notice that things didn't go well.
Thank you, sir. I have no further questions.
Ms. Salazar?
Thank you. Mike, I have a couple questions. Throughout your presentation, you have mentioned that this nonprofit was supposed to generate revenue from the seminars and the books and the clinics. Did the application for exempt status include any reference to tax return preparation?
Okay, so this was prepared by a law firm, and basically they described what it was going to do, but they didn't write down tax returns itself. My understanding, I don't know the inner workings of how this all goes with back and forth with the IRS, but my understanding is if IRS had a really good understanding of what I was doing, had they wanted there to be a prohibition about tax returns, they would have put that in their 501c3 permission.
And then also, did you review and sign the Form 1023 that was filed, or that the final sort of, did you review the final step after the back and forth with the law firm?
Well, yes. I mean, I was not in a position to go through it line for line for line by the law firm, for they would have charged me for that. But I'm sure they showed it to me prior to filing it. Who signed it, I don't recall. But, it looked good to me. That was the kind of review that I gave it, and away it went.
Great. Thank you for that. And then also you mentioned your commitment to education. You list some courses on a schedule on PET 17. But when I look at it, I notice that it stops in December of 2021. So I just wanted to ask you, have you had the opportunity to take additional continuing professional education in the last year?
Yes, I have. I've kept up a rather healthy schedule of that.
All right. Thank you. No further questions.
All right. Thank you. Mr. Dakar, any further questions?
No, Your Honor, but I'd like to provide a summary statement.
All right. Before we get to that, are there any further questions from the members of the board? Ms. Lotta?
Thank you, Your Honor. I have a question prompted from Ms. Salazar's questions. I know, Mr. Pibram, that you sought legal advice in your business entity formation, and I just wanted to understand, what is your depth of tax experience?
Income tax, personal income tax,
Yes.
corporate tax, or what?
At that time, at the time that you had formed, or did the paperwork to form that legal entity for the 501c3, what was your depth of experience in tax preparation at that time?
I had been for 30 years a tax practitioner doing returns, but I have no experience in the nonprofit area. My experience largely is in farming. I can take all the farming questions that you'd like to ask, but pretty much in farming, hospitality, food processing are the industries in which I worked.
Okay. Thank you for clarifying.
Any further questions from the board? All right, Mr. Dakar, summation?
Yes. So we've heard repeatedly from Mr. Pybram.
Mr. Dakar, I'm sorry, just for the interruption. For the folks who are participating remotely, are there any questions? No. All right. Sorry for the interruption.
We've heard repeatedly from Mr. Pybram that he didn't believe that his conduct was wrongful and that he had already informed the IRS of what he was going to do, and that he was basically, he's claiming that what he did was above board. But this was addressed presumably at his criminal trial, and then certainly at his administrative hearing in his CBA case. And this board's decision finds in its final paragraph, this is at page 31 of your materials, it says, however, respondent has not accepted responsibility for his criminal conduct. His testimony that he was not aware that his conduct was wrong is simply not credible. Further, respondent's assertion that through his attorney, he informed the IRS that the foundation would engage in tax preparation for individuals and corporations also lacked credibility. So we're hearing the same argument that he made unsuccessfully before, making it again. And the concern for public protection would be that he's has not started the path of rehabilitation because he's still contesting that which was already determined against him. He's not admitting his wrongdoing. He disagrees with the IRS tax position, even though a jury found beyond a reasonable doubt that he'd engaged in tax fraud, and yet he wants to get his license back to do tax preparation as a CPA. So that does seem to be a public protection concern. So thank you for hearing my argument on behalf of the people.
All right. Thank you, Mr. Dakar. Mr. Pybram, I will give you the last word.
Okay. I think we've pretty well been over the landscape. I don't want to reiterate all the things that I've gone over. But if we look at the core of what happened, it was my personal return. I did damage to myself. I didn't do any damage or harm to the general public, the client, or anyone else.
All right. Anything further, Mr. Pybram?
No, Your Honor.
All right. Well, as you heard earlier, the board will deliberate in closed session. You won't have an answer today, but you'll receive an answer at some point in the future, okay?
Okay, fair enough. Thank you very much.
So in terms of the record, exhibits 1, 2, 3, 4, 5 have been admitted for all purposes. Exhibit A, which is Mr. Pybram's supplemental narrative, has been admitted as administrative hearsay. With that, the matter is submitted, the record is closed, and we are off the record.
Your Honor, may I please get a moment to confirm?
Petition for reduction of penalty by Drake Whitlock, Office of Administrative Hearings, case number 2022120-653. Do we have Mr. Jacobson with us? Okay, great. We have already established a quorum of the board is present, but for the record, I'll ask each board member to identify themselves, starting with the board member farthest to my left.
Carrie Ann Farrell Hines.
Dee Dee Owens.
Christian Lotta.
Nancy Corrigan.
Michael Savoy.
Joe Rosenbaum.
Evangeline Ward.
Dan Jacobson.
Katrina Salazar.
All right, thank you. May I take the appearance of the Deputy Attorney General?
Ted Durkar, Deputy Attorney General.
All right, and petitioner, Mr. Whitlock, is not present. Is that correct, Mr. Durkar?
That's correct.
Have you had any communication with him regarding his appearance or non-appearance today?
No, but board staff did, and he indicated that he would just be submitting on the papers that he could not make the trip here.
All right. Are you ready to go forward with the presentation of the case then?
Yes, Your Honor.
Please do so.
All right. I appear on behalf of the people of the state of California by authority of Business and Professions Code Section 5115 and Government Code Section 11522 for this hearing on the petition for reduction of penalty by Drake Whitlock. My role is to assist the board and Your Honor in fact-finding. This role is not adversarial, but is intended to promote the public health, safety, and welfare. I'm here to ensure that the board and Your Honor have the facts and information that you need to make a reasoned decision. And so I'd like to turn now to the evidence in the form of a packet that has been sequentially stamped DW-PET001 through 85. The notice of hearing is at page 82. The petition is at pages 5 to 11. And Mr. Whitlock's narrative explanation of the rationale for his petition, that is at page 12. So I'd like to start by marking this evidence as exhibits, and I offer it into evidence.
All right. So the way that it's broken down in the memorandum that accompanies the exhibit is the petition for reduction of penalty, pages 1 through 55, has been marked as Exhibit 1. The financial hardship supplement number 1, which consists of page 56, has been identified as Exhibit 2. The financial hardship supplement sign 2 is page 57. That's been identified as Exhibit 3. The stipulated settlement and disciplinary order and decision and order has been marked as Exhibit 4, and that's pages 58 through 68. The first amended accusation has been marked as Exhibit 5, and that's pages 69 through 78. The license history has been identified as Exhibit 6, and that is pages 79 through 81. And then the notice of hearing has been marked as Exhibit 7, and it purports to be pages 82 through 85. But Mr. Durkar, on the actual exhibit itself, we have the declaration of service by certified and first-class mail, but I show that ends at on page 83. Pages 84 and 85 are case phone notes, which appear to be some sort of internal memoranda. Did you want to include that as part of Exhibit 7?
Your Honor, it's not part of the notice of hearing. I would urge that it be a separate exhibit.
All right, so pages 84 and 85, case phone notes, you want that to be Exhibit 8?
Yes, Your Honor.
All right, and that consists solely of those 2 pages. All right, are you offering Exhibits 1 through 8 into evidence?
Yes, Your Honor.
All right, hearing no objection, Exhibit 1 is admitted. Petition for reduction of penalty. Exhibit 2, financial hardship supplement, is admitted. Exhibit 3, financial hardship supplemental number 2 is admitted. Exhibit 4, stipulated settlement and disciplinary order and decision and order is admitted. Exhibit 5, first amended accusation is admitted. Exhibit 6, license history is admitted. Exhibit 7, notice of hearing is admitted. And Exhibit 8, case phone notes is admitted.
Thank you, Your Honor. I'd like now to provide a summary of the case.
All right.
Mr. Whitlock received a CPA certificate number 63202 in 1992. The license history, Exhibit 6, is at pages 78 to 81 of the packet. Since 2010, Mr. Whitlock's certificate has expired and become invalid a number of times for not paying his renewal fee or failing to complete continuing education requirements. An accusation was filed before this board against Mr. Whitlock in June 2019, as explained at pages 74 to 76 of that accusation, which is Exhibit 5. The case arose from Mr. Whitlock's conspiracy that aided an unlicensed person to operate an accounting firm and practice public accounting. What had happened was, after the 2008 death of a CPA who had owned and operated a registered firm, Mr. Whitlock and that CPA's widow created a new firm in which Mr. Whitlock was the 51% owner. Mr. Whitlock did not register the firm with the CBA or exercise supervision over its work, and the firm performed compilation reports but didn't engage in peer review. The accusation thus charged Mr. Whitlock with 6 causes for discipline: conspiring with an unlicensed person, failure to provide supervision, practicing for an unregistered firm, failure to complete and submit to peer review, failure to respond to CBA's inquiry, and unprofessional conduct. Mr. Whitlock entered into a stipulated settlement that was adopted by this board effective February 2020. And that stipulation and order revoked his license, with the revocation stayed pending 3 years of probation, with standard terms and conditions, an administrative penalty of $5,000, payment of $4,372 in costs, due 6 months before the expiration of probation. Mr. Whitlock seeks a reduction or elimination of the costs and the administrative penalty based upon his claim of extreme financial hardship. His 3-year probation period is almost expired, and that 3-year period would end February 24th, 2023. Mr. Whitlock isn't present today, and his claim of financial hardship is supported by his narrative at page 12 of the packet. That's Exhibit 1, and then those Exhibits 2 and 3, pages 56 and 57 of the packet. He wrote that his recent experience with employment has been that accounting firms are only hiring people like him for part-time, temporary work during busy times of the year. He reports that he's working part-time currently, but has experienced increases in the cost of living, including rent, storage fees, and gasoline. CBA staff reached out to him to request more information and some documentation in support of his financial hardship claim, but Mr. Whitlock did not provide anything else. Mr. Whitlock has paid a little over half of the costs and a little over half of the administrative penalty due under the disciplinary order, but he still owes $2,056 in costs and $2,350 of the administrative penalty. Mr. Whitlock recently violated probation when he let his license expire on November 30th, 2022, but then he renewed it, and it is now renewed and active through 2024. Mr. Whitlock states in his petition that if his request is granted, he will continue to work in public accounting as an employee for others. That concludes my summary of the case, and I hope that covers everything that you need to know in order to reach a reasoned decision in this matter.
All right, so Mr. Whitlock isn't present, but I will open it up for the board if there are any questions for Mr. Durkar.
Your Honor, if I may advise the board, this is Helen Joffrey, Board Counsel. I did want to let the board know that Mr. Whitlock's probation terminates on February 24th. Under our standard effective dates for orders, this means the effective date would actually be 2 days after his probation were to terminate. And so the board may wish to make the effective date of the order sometime briefer than his termination of probation. Further, being that he is admittedly out of compliance with his probation in that he has not paid his entire amount due with 6 months, And then he responded, of course, by filing this petition. I wanted to let the board know in case they had any questions for Mr. Dakar or Mr. Franzella. Oh, and I do apologize. The board is not able to know or ask if a petition for revocation of probation has been filed or intends to be filed prior to this matter.
It's over in a short period of time.
I'm sorry?
But it's over February 24th.
Yes, and today's the 26th, and typically we have it 30 days, which that means it would be effective on February 26th, 2 days after his probation terminates.
All right. Anything further then on this matter? Ms. Lotta?
There you go. Ms. Corrigan. Do we just hold questions for council till closed session?
You can, but if you have questions for Mr. Dakar or Mr. Franzella, you'll need to ask them now.
All right. Anything further?
I think Salazar had a question.
Ms. Salazar?
Yes, thank you. I just was trying to clarify. PET 7 says that this person's complied. Oh, never mind. I just answered my own question. Thank you. I figured it out. No more questions.
All right. Anything further? All right. With that, exhibits 1 through 8 have been admitted in evidence. The record is now closed, and we are off the record in this matter.